Well, my trial mind is about to explode about what's happening here, but I got to bring on two awesome guests to carry us through to talk about this. The first is my good friend Charles Mittelstadt. He's from Atlanta, Georgia. Let me tick it off real quick, folks, because we got a lot to talk about. He's a criminal defense investigator representing Fortune 100 companies, athletes, entertainers, cases of national significance, TV legal analysts across the spectrum of networks. And he's also a consultant for security and investigations for corporations. And you can find him at Defense Mind is his Twitter handle. And Natalie Jackson. Hello, Natalie. How you doing? Out of Orlando, Florida, from the law offices of Natalie Jackson, civil rights, civil litigation, wrongful death, criminal, former public defender who I went against many times in my young career as a young assistant prosecutor, a former U.S. Naval Intelligence officer, yikes, and certified multi-million-dollar advocates club, adjunct professor at law school. Welcome, guys.
Thank you so much, Bob. Pleasure.
Hey, guys, we were talking about this offline. I am losing my mind that this is trial by transcript. How can a person, I'll ask you first, Natalie, as a public defender, how does this guy get a fair trial when we make such a big point about the credibility of witnesses, their demeanor when they're testifying, and we know full well now the defense can't cross-examine, in this particular case, those witnesses, because you can't cross-examine a transcript. Natalie, what's happening?
Good point. This is just what happens when you have a trial that's 27 years old. I mean, some of the witnesses die, some of them are not available, so you have to do the best that you can do. For a public defender, it's really hard because you're so correct about the demeanor of a witness being important for a jury to see and test their credibility.
Right. And Charles, another thing, too, that we know from the courtroom scenario is that even in a trial where the jurors have heard the actual witness testimony and they ask for readback of that testimony, that often it's not as compelling as the witnesses themselves. And it seems like they kind of gloss over when they're listening to copious amounts of testimony in the very case that they were listening to. What are your thoughts?
Absolutely, Bob. I mean, I've been part of multiple trials that have retrials, and you want that live testimony when possible because memories evolve, memories change. From a defense perspective, you want the ability to cross-examine these witnesses to investigate whether there's any sort of testimonial cross-contamination that may have taken place, whether they've adopted other versions as their own, as firsthand information, maybe something that wasn't explored adequately by previous counsel in a previous trial. So you would never just want to rely on a transcript. That's ludicrous.
Yes, and listen, real quick, Charles, you brought this up, and I think it's a worthy point. We could talk about it. One of these is the identification that was made by Antonio Holmes, which was very shaky and wobbly and flaky. And now that detective is deceased, and as we know in best practices, those kind of identification procedures wouldn't even be allowed today, not to mention the witnesses even available.
1,000%, Bob. We know that faulty eyewitness identification is the leading contributing cause to wrongful convictions. We know this based upon the good work of the Innocence Project and the fact that they were able to correlate these wrongful convictions and compile this data. I was on the Legal Advisory Committee for the Georgia Innocence Project, and I can tell you that one of the best practices has to do with memorializing this process, right. and that would have cleared up this entire issue right here. And also the confidence statement that is not part of this.
Right, Charles, we're going to get to all that because it's really important stuff on witness identification, but we have to take a quick break. I'm on fire about this case. Law&Crime Network will be back on the other end of the break. We are at Stanley Liggins, okay? Guys, you know I have the appellate division's decision in Iowa. I showed it to you before. I've added to it how not to prosecute a case, okay? We have Charles Mittelstadt with us and Natalie Jackson. Guys, even the court reporter's getting confused. Natalie, about are you talking now as you to this person, or is this the testimony from the testimony of the previous testimony that we're reading in this trial by transcript? Thoughts?
That is the worst way to do a trial. I honestly feel sorry for both the prosecution and the defense. But in these cases where a trial is so old and where a case is so old, in this case 27 years, you'll work with what you got.
Yeah, and listen, you know, Jennifer Ann Lewis, the poor girl here who was victimized, the victim of this case, Stanley Liggins, the citizens of Iowa, and justice itself have been denied by the folly of the prosecution in this case. This is a 28-year-old trial, 77 reports were withheld from these witnesses, from the defendant. There's no way to get that back. The genie is out of the bottle. How can this man receive a fair trial as a homicide prosecutor, a person who led an agency, Charles? I would have moved to dismiss this case because I don't believe you can get justice, and it's not about scoring convictions as a prosecutor. It's about doing the right thing. What are your thoughts?
I could not agree more. This is outrageous. It's a farce. I mean, the fact of the matter is the defense is handcuffed to the abilities of the previous counsel, and as you aptly point out, this is before the reports even surfaced. This is a complete and total farce. I've been a part of cold cases that were prosecuted 26 years after the fact. I had the case against or involving Detective Sam Guy. They did not use any sort of trial transcripts or any sort of testimony that was read into the record or even statements that were read into the record. They relied on their ability to bring a case against the defendant. And by the way, they secured a conviction, but they did it cleanly, they did it appropriately, and they did it justly. And that is not what we're dealing with here at all.
Natalie, real quick, I mean, that's a great point, Charles, but Natalie, you know, we have constitutional issues here, the right to confront witnesses, the right to a speedy trial. Justice delayed is justice denied. How can you cross-examine these transcripts now that they have 77 reports, some of which are exculpatory?
Right, and that's the problem in these cases. However, they have been cross-examined by previous counsel. I will tell you, one of the things, and I think you brought this up, this is so egregious, and this is what happens when you have prosecutors who unethically withhold information, and you have now all this time cost, not only to the defendant, but also to the victim's parents and to everyone who's been there. It's a really unfair thing, and this is what happens when you have prosecutors who don't play fairly.
Well, listen, let me tell you something. When I was the boss, they knew you had a one-way ticket out of the office should you ever withhold exculpatory information. Say goodbye to your career on that one. Unfortunately, it happens more and more, and here we are with a 28-year-old trial. We're going to be back on the other end with more commentary. Okay, so Charles, Natalie, we're watching the confusion that is created when you have a trial by transcript. And so, guys, this is an evidence rules case for those viewers out there and for our people in the chat room. Love what I'm seeing in there. Keep asking questions. But Natalie, I'll throw this to you because it's a sophisticated evidence rule question about, of course, previously sworn testimony subject to cross-examination is allowed to come in most instances. But I think this case is a little different because the defense never had the opportunity and availability of the 77 other statements. And that is particularly relevant with this case because the car, issues about the car were suppressed, and especially an FBI report that indicated that it was a car different from the defendant's. How do you get around this?
Right. Here, I mean, this question it's going to be paramount to the case because what you have is a case that's old. You have witnesses saying they don't remember. So at trial, you have to testify to your memory if you're a witness. The argument here, the hearsay argument is this impeachment by presenting the transcript and having the witness read from the transcript, or is this a refreshment or a recollection of memory? I think it's a very interesting argument, and depending on what Iowa law says as far as hearsay, what hearsay exceptions they adopt, I think that the judge has properly ruled that the prosecution has to present the transcript the prosecution has to ask the victim if there's something that can refresh their memory if they don't remember. And then show them the transcript, they read the transcript. If they say they still don't remember, that witness has to be stricken.
Right. So, Natalie, just so our viewers know, hearsay is essentially an out-of-court statement used to prove the truth of the matter asserted. And then there's a number of exceptions to the hearsay rule, which is what we're talking about. And those exceptions are founded in the basis of it being reliable. The most common one would be an excited utterance. Somebody blurts something out in the middle of witnessing a startling event. It's inherently reliable, or statements given to a medical professional for say, you're treating yourself. But, Charles, I want to go back to a point that you mentioned offline a little bit, is while we may have all of this, the jury is still aware of the fact that there were 2 previous trials that had occurred. They're not allowed to know what the verdict is, but give me a break. They know they're there because he was convicted. Otherwise, why would they be there? What are your thoughts?
It's entirely prejudicial. And listen, to the earlier point, the very fact that they're even having this discussion about being able to refresh a live witness with previous testimony, it highlights this issue of testimony that's read entirely into the record via transcript. There's no ability to cross-examine that, to peruse someone's memory, etc. And just as Natalie said, if they can't remember, as a live witness, they can't remember. So the fact that they're even talking about this with this live witness just highlights the shortcomings of reading testimony into the record. It's crazy.
Yeah, and you know, guys, as we indicated, being a prosecutor is about doing justice. It's not about merely seeking convictions. He served 28 years. They're the ones that withheld stuff. They're the ones that didn't give exculpatory information. They should just dismiss this case, in my mind. That's what we would have done. We'll be back. We are breaking down the Stanley Liggins case. They are in recess right now. I got great guests, Charles Mittelstadt with us and Natalie Jackson. We've been breaking this case down, but let's get right now to top crime stories, and we'll talk about one of those stories that's pretty fascinating on the other end.
Here are today's top crime stories trending on Law&Crime.com and across the country. A man in California accused of being a serial dine and dasher, leaving his unsuspecting dates with large dinner bills before slipping out of restaurants, is now facing felony charges. Investigators allege 45-year-old Paul Guadalupe Gonzalez met women through dating apps and would skip out on his dates before the check arrived between May 2016 and April 2018. Gonzalez now faces 11 felony counts of extortion as well as other felony and misdemeanor charges. The Dallas police officer who allegedly entered her neighbor's apartment thinking it was her own and fatally shooting the man now faces a manslaughter charge. Officer Amber Renee Geiger reportedly returned home to her Southside Flats apartment after a shift but entered the wrong apartment. That's when Geiger shot and killed her 26-year-old neighbor, Botham Jean. Geiger's blood was drawn after she reported the shooting to local dispatch, but results haven't been released yet. Police in Cincinnati released surveillance footage of the gunman who killed 3 at a Cincinnati bank. 29-year-old Omar Enrique Santos Perez can be seen walking through the bank with a briefcase full of ammunition, indiscriminately firing at horrified bystanders in the lobby of the 5th Third Bancorp headquarters. Officer body cam footage shows the hectic scene. Santa Perez was pronounced dead at the scene. Those were today's top crime stories. I'm Anthony Velez for Law and Crime.
Well, thanks, Anthony, for that. Guys, Charles, Natalie, I mean, that cop case, shooting scenario where they took that guy out was some pretty amazing police work. Charles, what did you see in that scene in terms of how they approached the scenario? Very tense and saved a lot of people, probably.
Oh, thank goodness. I mean, what a quick and efficient response by law enforcement. It was already tragic, could have been far, far more tragic if he had gotten loose in the building. But a tremendous job by law enforcement to identify the suspect and engage him right away.
Probably the best thing I did when I was the county prosecutor was I actually was allowed to go through the Police Training Commission course on firearms. And I got to tell you, people don't get it. It's tense out there. There's a lot of them. Your blood's pumping. They were very calm, cool, collected, very measured. Natalie, you represent clients, and let's face it, in the criminal justice system that have all sorts of mental illnesses and addiction issues. I mean, do you find, as I do, that there's something particularly bad going on, and people that are right underneath the surface are just violent and getting more violent and more crazy and hurting more innocent people?
I think that there's a big lack of resources to help people. Most of the time when we hear things like this with some sort of mental illness underlying, there was an opportunity for a person to be helped that was not capitalized on, and that could have saved lives. So yeah, I do find that we see more of it on television because, for instance, this video is amazing to me that this video is on regular television. I applaud the police for what they did, but this is a very violent video for anyone to show. So when you have things like this on television that are just traumatic, you know, I think that plays a part of it, and I think that we're just seeing more and more of it on television. I think that these people have always been out there, but television is just really showing a lot more of it, and it's kind of sad.
Right. Point well taken about the fact that it may just be a little bit more that you see, but I don't know, dealing with these cases in and out, I see a level of violence in my mind that I haven't seen as well, where innocent people are the targets of the wrath of these people. Anyway, listen, in the Stanley Liggins case, we had, I'd like to say testimony, but rather a transcript read of Lloyd Easton. Let's go listen to this testimony, why the prosecution put it on, and I'll get back with Charles and Natalie on the other end. Yikes. Okay, we are in the Stanley Liggins case. I got Charles Mittelstadt with us and Natalie Jackson. We're going to have to take a break. But hey, guys, things are moving so quick at the Law&Crime Network. Somebody actually left one shoe. They flew out of it. That's how fast we're moving. We'll be back on the other end. Okay, well, welcome back to the Liggins trial. This is I don't even know if these are actors. These are real people. It's just really conflated, confusing, and confounding to me. But anyway, of a transcript of Sergeant David Holden, another witness who's unavailable for the defense to cross-examine because the prosecutors for 28 years prosecuted a case where they decided to withhold 77 police reports, some of which were so exculpatory, or in other words, could potentially have led to a not guilty verdict, that the Iowa appellate courts said, and as I put here in my notes, how not to prosecute a case, that it led to now a second retrial. Charles, you guys, Natalie, I know that you guys are really offended by this. I can hear the comments that are going along as we're doing this. But Sergeant Holden, and before that was Lloyd Easton about the car. Charles, what are you hearing from this testimony that even further makes the idea that this man can get a fair trial an impossibility?
Well, it is, because, again, everything we've mentioned before, there's no ability whatsoever to cross-examine him, to attack his investigation, any shortcomings that may have occurred. But we also heard, there's some other mistakes. I mean, they take Liggins into the specific interview room because it has audio-visual capabilities to memorialize the interview, and as it turns out, it's not working. So none of this. We're relying entirely not only on his memory of the interview and whatever notes he may have taken, but now we're relying on some transcript of all that. It's just really crazy. It'd be wonderful to have the actual videotape of that so that the jury would not have to rely on any interpretation, but could actually hear and see for themselves exactly what Liggins said.
Charles, just also real quick, we were in the middle before, and I think it's relevant, especially in light of what you just said right now, about how identification procedures have changed so much based upon scientific information, and the fact that this witness, the police officer that conducted the investigation, and recordings that aren't even available, was not done pursuant to what we would do today. Do you think that that substantially impacts this case?
I think it's one of the biggest components to this case, Bob. I mean, the fact of the matter is this issue of a faulty eyewitness identification has been universally accepted as the leading contributing cause to wrongful convictions in this country. In fact, most states, not most, half of this country at this point has actually legislated the reforms, the best practices, which include basically a procedure by which the photo array is conducted, how the lineup is constructed, an admonishment at the beginning to let the witness know that the person may or may not be in there, and then a confidence statement at the end so that you have some measure of their level of confidence. In this case, we know he said he wasn't sure, but we can't cross-examine him.
Great. And you know what, Natalie, we'll get back to you on the other end, but my dad used to say, 86-year-old trial lawyer, number one way a person will be convicted falsely is by bad identification. We'll be back at the other end of the break. Welcome back. We're in the Liggins case, and Natalie, I wanted to get back to you. Charles was giving us some great information before, but in this decision from the appellate court in Iowa, they referenced the great case of Brady versus Maryland from the great year, may I add, Charles, 1963. I'll leave it to you to figure out why that was such a great year. But nevertheless, Natalie, Brady is talking about the right of a defendant to have exculpatory information. Can you explain that a little bit for us?
Yeah, exculpatory information is any evidence that could prove the innocence of a defendant. The prosecution has to turn that evidence over. I think a lot of viewers may not know that prosecutors and defense attorneys have different roles. Prosecutors represent the state, so they have to play really fair, and because you're talking about someone's life and liberty. And here, the prosecution didn't do that, and what they did was there was a 9-year-old girl who was killed. And we can't forget that. And you have a sergeant who interviewed the defendant, and the defendant lied about knowing or seeing the 9-year-old girl that day. But because of their lies and because of their withholding of exculpatory information that they may not have even needed to prove their case, now we're here 3 trials later, 27 years later, and this little girl's family has to relive this. That's the sad part of this to me.
Right, you got to play by the rules. But let's go to page 14 of the Iowa court's decision, because maybe this would be considered exculpatory when they indicate that they failed to let them know that the stepfather allegedly made statements of his desire to videotape himself engaging in sexual conduct with the child. And this person is around at the time of this murder. Kind of relevant information, don't you think?
Very relevant.
Unbelievable.
Very relevant.
Unbelievable.
And I think,
if that's not exculpatory, nothing is.
Right. And so, and how do you get that genie back in that bottle, Natalie? That's my point with this.
You can't. You can't get it back in the bottle, so you have to go with what you have now. And while the defendant deserves justice, this 9-year-old girl's family and her friends deserve justice too. So you do have to have this trial again, whether or not you like it, whether or not it's clean. This trial has to happen again.
Well, this is kind of an interesting juxtaposition here. Me, the prosecutor for most of my career and a person who made the ultimate calls. You, the public defender who's represented defendants. And I believe so much in what prosecutors do, and our job is to do it correct, that like my boss used to tell me, sometimes you got to hold your nose and do what you need to do the right thing, because I just don't see how this guy could get a fair trial. He spent plenty of time in jail. This was all created because of the state. I agree with you. The state has caused them to be victimized. And we're going to go back into a scenario now. My producers will let me know where we're going with it and give me a little bit of a countdown. And we're going to go to back at the court, and we'll be back. Okay, the trial by transcript is still underway in the Liggins case, also known as the Liggins case. We also listened to Brenda Adams. I had to actually ask, is this a real person, not a real person, an actor, not an actor? I don't know. We have a break. We're going to come back on the other end. Okay, welcome back. We are in the Stanley Liggins case. Charles Mittelstadt and Natalie Jackson have been helping me break this case down. Interestingly enough, the public defender and Natalie and her seems to be a little bit, we're flip-flopping positions from where we were, and that's where we left off, Natalie. As a prosecutor, this is offensive to me. I believe that it's important to get it right, and sometimes you got to hold your nose, which what my last comment was, and you have to do the right thing. I don't see how this guy gets a fair trial. Charles, can you finish up that piece that you were talking about the differences in eyewitness identification and what we've learned scientifically and how we do it differently today in terms of how cops now do IDs?
Absolutely. So we know, going back historically, looking at wrongful convictions, and these are factually innocent folks, been able to look at that, and in 75% of those wrongful convictions, faulty eyewitness identification was identified as the leading contributing cause. So the difference is in terms of best practices. First of all, there's what's called a double-blind administration, which means that the officer that's involved, the detective involved in the investigation, should not be the one who's actually administering the lineup. In other words, whoever's administering it should not know the true identity of the suspect. And that way there's no undue influencing, either intentional or unintentional. That's one primary reform. The second is the whole process needs to be memorialized. The third is there's an admonishment at the beginning that essentially says, look, the person that you saw out there may or may not be amongst the photographs you're about to see, so that there's no undue pressure. And then there's also a confidence statement at the end, which is something that the witness does in their own handwriting. They write it out and basically say, hey, I think I'm 50% sure, I'm 100% sure, I'm 60% sure, whatever it may be. And then this entire process, by the way, is videotaped, so that in this exact scenario, where in some cases you are coming back years later and looking at this, nobody needs to guess what happened, what was said, the context of it, the exact wording of it, whether a witness sat there for minutes on end without being able to pick somebody out, and then came back 2 days later and only then pick somebody out, so that the defense can appropriately look at this, and the jury can see with their own eyes exactly how this process took place.
Right. Excellent description and agreed. Natalie, also, back in the day when I started trying cases as a baby prosecutor, we didn't have videotaping of confessions and identifications, and everyone just seemed to waive their rights and give a statement voluntarily. But if, ironically, once the recording devices went on that they couldn't even see in the room, it seemed like everybody equivocated, and they became very powerful defense tools. Thoughts?
Yeah, imagine that. Video changes a lot of things. It changes what we really know, and it's really the only thing that's objective. When you have testimony of people, it's subjective to how they feel, how they can be influenced and other things. So when you do have video, you actually see what's going on. That's one of the things, unfortunately, in this case, we're seeing a lot of problems when you're relying on things that people said.
Right, and especially when you're dealing with a case that could be over 28 years or about 28 years old. Listen, we've all known from time immemorial, guys, confirmation bias. The cops believe this is the suspect. I've dealt with it as an assistant prosecutor, where we actually dismissed 2 or 3 major cases because of suggestive identifications, confirmation bias. Cops think they're doing the right thing, but unfortunately they're not the judge, the jury, and the executioner. Great stuff. I got Charles Mittelstadt with me. He is a criminal defense investigator out there in Atlanta, Georgia. Natalie Jackson, former public defender's got her own practice. You guys are nailing it, killing it, knocking it out of the park. We got one more clip, folks. Get in that chat room. This is gavel to gavel coverage. You got to love this Liggins case, because we're going to go more into the Iowa Appellate Division's reasoning as to why we're here for a third time. And I agree with Natalie. It not only is an injustice to the victim, as Natalie's indicating, and their family, but also to the defendant in the case and to justice itself. In my opinion, this is how not to prosecute a case. We're going to go listen to one more clip of Mary Ann Watson, who is a neighbor of the victim, and I have my 2 great guests on the other end. Okay, Charles and Natalie, I think that was that a real witness, like a real person being asked questions in court? Am I making a mistake, Charles? You're the investigator.
I think it was a hologram. I mean, they're bringing everything into this one, so who knows? But, again, it's such a hodgepodge. It's a hybrid of a trial between historical information, live witnesses. This is exactly what Blackstone had in mind when he came up with his law, right, is this very type of case. The only hope that I really hold out, Bob, is the fact that there's so much that's been made by the appellate court about these 77 exculpatory reports that I'm hoping that the defense is going to put on a super robust case, and they're going to make up a lot of ground that will overshadow a lot of this very prejudicial testimony right now.
Yeah, great. Natalie, why do I think that if there is a conviction again in this case, why does my prosecutorial trial antenna telling me we're going to be back again?
Right, because of the hearsay evidence. I understand exactly that. But I will say this testimony that we just heard from Mary Watson was very convincing. And this is why you need live testimony. She said that she saw Jennifer talking to someone in a red car, and we know that the defendant has a red car in this case. This is the kind of testimony that you need, and you need to see the demeanor of the person. She was very strong. Her demeanor was strong. She spoke as though she knew what she was talking about. So, this case, you might see another conviction and you might see another trial.
I personally think, just so everybody understands the basis of this, Natalie, this was done on post-conviction relief. It's a technique, a tool in the law that kind of can go on and on and on and on in perpetuity. And a previous court had actually denied most of these arguments that this would have had a substantial effect on the verdict. And the Court of Appeals, that the decision that I keep having in front of you right now, you could tell, and we're going to get to it at some point in time, basically spanks them and says the cumulative effect of all this stuff very well could have affected the outcome of the case.
Right. And one thing that I want to say is that just the appellate courts don't take this stuff lightly because they understand the cost of redoing these trials. So
Right.
most of the time they will try to uphold a conviction if they can.
Okay, great stuff. Guys, we're going to go to one more clip, and on the other end, we'll come back with more Law and Crime. Okay, we're in the Liggins trial by transcript, and I've had two great guests that have been with me, but unfortunately they've got to go. I want each one of them to give me a little bit of a closing argument about what they saw in a minute or less. But first, let's start with ladies first. Natalie Jackson, Orlando, Florida, former public defender, intelligence officer. She now has her own practice. She gave some great commentary. Certified life coach. Hey, you can find her at Nat Jack Tweets. You got a minute, Natalie. What are your thoughts?
My thoughts are that this case is all over the place. You have a transcript of Sergeant Holden, who was the lead detective in this case, and he says that the defendant admitted that he lied about seeing this little girl, but he didn't have any audio or recording of it. You also have Mary Watson, who says that she saw Jennifer Lewis talking to someone in a red car, and the defendant has a red car. I think that we have to listen more. I think the jury's got some work to do in this case. I think that the defense is doing a great job, and I think the prosecutor is too with what they have, which is unfortunately a 27-year-old case.
Yeah, that's right. Okay, Natalie Jackson, thank you so much for being with us. Can't wait to have you back on again. And my old friend here, Charles Mittelstadt, what can you say about this guy? Criminal defense investigator, Fortune 100 companies, cases of national significance, TV legal analyst, just like Natalie is, a consultant for security firms and investigations for corporations. He's at Defense Mind. I don't have to spell that one out. That's easy enough. So here's your closing. You got a minute, Charles. What are your thoughts?
First of all, I'm going to hire you as my agent. You're awesome. Thanks, Bob. Such a bizarre case. First of all, we can't, forget the fact that this involves the very tragic and violent death of a young girl. And as Natalie so aptly pointed out, there's, family is being put through this again. But we also can't forget that there's a defendant who's on trial here. And while he's been through two previous trials, he sits here with a presumption of innocence. And so he should be afforded every bit of due process that he's entitled to under the Constitution. Right now, I'm wondering, where the Ouija board is. I mean, we're hearing so many witnesses that are speaking from the dead, and it's baffling to me. The prosecution's primary argument is it's an argument of proximity. So, yes, while we've heard testimony from a neighbor and the vehicles that match, I mean, that's no different than finding a pubic hair in the bed of in a case where you have defense arguing consensual sex. So does that mean anything or not? Would you not expect for him to have had some contact given that they lived right near each other? So because this case is so intricate and the evidence is so important, that's why it's even more important to get it right. And so far, they haven't been able to get it right. And that's why 28 years later, here we are again.
Right. Well, listen, Natalie, Charles, you guys have been amazing. I really appreciate it, your time. We're going to have to go to a break. But before we do, as you guys both know, this is my favorite prop of the day. How not to prosecute a case. This is the multi-page decision that's all marked and highlighted from the Iowa Appeals Court that got us where we are right now with this case. Charles, Natalie, you have been excellent guests. Thank you so much for coming on.
Thank you.
We'll see you soon. Okay, guys, you're at the Law and Crime Network, a Dan Abrams production, gavel-to-gavel coverage. We probably should have said to Charles before he left, because he does a lot of defense investigations for these Fortune 100 companies and things of that nature, is we're still trying to figure out who actually left the studio with only one shoe. You know, it certainly isn't mine, from what I'm being told. Somebody has walking around, because we are flying so quick at the Law and Crime Network, gavel to gavel coverage. Get into that chat room. We love to see you. On the other end of the break, we'll have more Law and Crime.